Biggest mistake is not having a plan at all. It's tough to think about inheritance. It's tough to think about death. That's the big scary one. That's actually what hits more families than estate taxes now. The big loophole in capital gains for people who inherit property is the basis of the asset.
Okay.
What is a trust? So a trust is a relationship between people.
Right.
This is going to be hairy. This is going to be sticky. This isn't going to be easy peasy lemon squeezy. Yes, I've got this nest egg. Yes, I'd like to protect it, but really, chiefly, I'm concerned about my real estate. That's
right.
I could get on Main Care tomorrow. I don't have $750,000 of equity in my house, but I just don't want the state to get the house when I die. Because great lawyerly advice, right? Don't lie. Don't lie. Cutting edge ethical advice. And this is the risk whether you use a trust or not. And the real danger is that you give away the house to the kids or in a trust for the kids. And somewhere in between giving it away and 5 years, you need care.
Welcome to the Lone Pine Real Estate Company podcast and radio show, creating solutions to navigating tricky real estate waters. I'm your host, Rachel Umstead, broker and owner of Lone Pine Real Estate Company here in Midcoast, Maine. Real estate isn't always smooth sailing. Whether you're buying, selling, investing, or just trying to figure out your next step, the path can feel overwhelming. That's why this podcast exists, to bring clarity, confidence, and creative solutions to the complex world of real estate. And fun. We all want fun. Each episode will dive into real stories, practical solutions, and expert insight to help you make smart decisions and avoid common pitfalls, all while staying grounded in what matters most: your goals, your future, and your peace of mind. Please note this podcast is for informational purposes only and does not constitute legal, financial, or real estate advice. Listening to this episode does not create a client-agent relationship. Always consult with a licensed professional about your specific situation. So grab your coffee and join me under the pine. Together, we'll chart the course. Welcome to the Lone Pine Real Estate podcast and radio show, where we dive into real estate topics. I'm your host, Rachel Umstead. I'm a licensed Maine real estate agent. Today, we're discussing a crucial topic about how to protect your home and assets as you age, including understanding inheritance, taxes, trusts, and Maine Care considerations. Joining me is Laura Curtis, an attorney licensed in Maine and Massachusetts, who focuses on estate planning, trusts, probate, and elder law. But before we begin, we're going to do a couple of disclaimers, and one is this is our very first podcast. It's Laura's first podcast as a guest and my first podcast as a host, so please be gentle with us. And another disclaimer is I'm a Maine licensed real estate agent conducting this interview with Laura Curtis, an attorney licensed to practice law in Maine and Massachusetts. The purpose of this discussion is for informational and educational purposes only and does not by itself create an agent-client or an attorney-client relationship with the listener. Nothing shared during this interview should be considered legal advice or real estate advice. For advice specific to your situation, please retain a qualified professional. So we will begin. Laura Curtis, thank you so much for being the first ever guest on the Lone Pine Real Estate podcast and radio show.
Rachel, thank you for having me. Thank you for having me to your beautiful new office in Camden, Maine.
Yes.
Beautiful.
Thank you very much. We've been here about a year, and in 1 week, or no, this week, it's our 2-year anniversary as a company. So we're very excited. And I'm really excited about this topic. It's huge in Maine. But before we dive into the topic, I want to ask you about you. So Tell us a little bit about you as a person and how long you've been practicing law.
Sure. So I started practicing law in 2014. So it's been a little over 10 years now. I'm licensed in Maine and Mass, but my career has been exclusively in Maine. I started at a large firm in Bangor and got married to a nice man from Rockland. And he jokes that I found my job at my current firm, Strout and Payson, in Rockland. He says, well, my wife got this job in Rockland, so we just had to move back to Rockland, which is backwards, of course, because he was dying to move back here.
Exactly.
And I'm very happy at my firm. It's a great firm. It's been in Rockland since 1960.
Wow.
And it's a wonderful practice. I fell into this practice area. I didn't think I was going to do trust and estates. I didn't take a single trust and estates class in law school.
So yes, that brings up the next question, which is why, like, you kind of fell into it, which is it's huge in Maine because you can correct me if I'm wrong, but I think we have the oldest population per capita in the nation.
We do.
So tell me, like,
we do. Maybe Florida might be sometimes it's Florida, sometimes it's us, but it's pretty close.
So you decided to focus on trust, estates, and elder law. So tell us, like, what triggered that.
I did fall into it. I thought I was going to be a trial lawyer. Like my dad and my uncles were all trial lawyers.
Oh, wow. So you come from, like, a lineage of...
Yes. I'm the only one that went into it. My dad and all of his brothers were lawyers, and I was the only one of their children fool enough to go into law. But I did. I went into law school, and I liked it a lot, and I thought I would go into trial law like they did. But for various reasons, that family law firm had to close down while I was in law school unexpectedly.
Family law firm.
Yes.
That's amazing.
Yep. And my uncle was the last one in there, and basically for health reasons, he had to close it. And so I was looking for a job, and one became available in this practice area, and I knew one of the lawyers at this large Bangor firm before my life in law school, before her life as a lawyer. And she encouraged me to apply. And I said, oh, but I never took a class in that subject area. Are you sure? And she said, I think you'd be a good fit. You should apply.
Oh, wow.
And I did. And I loved it. It's been a wonderful practice area.
So they focused on this type of law?
It was a large firm with many different practice areas, one of the largest firms in Maine. And I was in the trust and estates practice.
Oh, wow.
So it was a wonderful learning opportunity.
Okay, great.
Yeah.
So let's dive a little bit into one of those topics. Like, what, as people age, or let's do this first. Like, as people are setting up their real estate, or, what are common mistakes people make if they want their children to inherit the property?
I think the first mistake I see people make is, if their goal is for their children to inherit the property, that was your question. If they want their kids to inherit, what's the first mistake or the biggest mistake they make? Biggest mistake is not having a plan at all.
Okay.
Avoidance is probably the biggest problem.
Right.
Where people, it's tough to think about inheritance. It's tough to think about death. I mean, I don't want to sound glib about it. It's a heavy topic for people. I do wills and trusts and estates for a living, so I can be a little glib about it sometimes. I'm used to dealing with it, but for some people it's very hard mentally to think about planning for those things.
Yes.
But if you own real estate, if you have real estate, it is worth making a plan.
So plan's number one. So where do, like, trusts come into this? Like, because, I don't know, some people, I don't fully understand trusts either, so I'm guessing that the general population doesn't understand. So does everyone need a trust, or what are your thoughts on that?
Different lawyers will have different opinions on how wonderful trusts are. And I like trusts, don't get me wrong. I love a good trust. But I find, especially in this area on the Mid-Coast, the complexity inherent in a trust is not always appreciated. There are people who are overwhelmed by a 5-page will.
Okay.
The legalese in a 5-page will seems dense and overwhelming to them. So that person might not be happy with the trust. It kind of depends on what their goals are. The other issue that you pointed out is, well, what is a trust anyways? Like, how is a trust different from a limited liability company or a corporation? We kind of know what a corporation is. We all know what, like, Coca-Cola is. We've all been in a club with a president and a secretary and a treasurer. We understand stocks and shares just because that's been around for a long time. Trusts have been around longer than any of those things, but people don't use them frequently, so we don't always know what a trust is and how it works. So I'll start with that. What is a trust?
Okay.
I'll use a couple of cheesy examples of what a trust is. So a trust is a relationship between people, and it's usually sort of 3 classes of people. a grantor or a settlor or a trustor. It usually always ends in or.
Okay.
That's the person creating the trust. That's the person whose stuff is going into the trust.
And typically, that's real estate. That's the person who owns the real estate.
Yeah, that would be the person who owns the real
Okay.
estate. They would be the grantor or the trustor or the settlor. Then there's the trustee. That's the person who holds title to the asset once it's in the trust.
Okay.
So they're holding it in trust. Then there are the beneficiaries. Those are the people for whose benefit the property is being held. Those are your three sort of groups. So I'll give a cheesy example of a trust. So this is a trust that anybody can get their head around, I think, I hope. If I take $100 out of my purse, it's my $100, and I give it to my husband. I say, sweetheart, here's $100. It's St. Patrick's Day. I want you to buy a cake and some decorations for a little party for the kids.
Okay.
And he says, okay. That's essentially a trust. I'm the grantor because it's my $100 to give.
Right.
He's the trustee. I'm giving it to him, but I didn't say, here, sweetheart, I love you so much. Here's $100. I said, here's $100. I want you to go and buy cake and party decorations for the kids. So the kids are actually the beneficiaries of this setup.
And this, so let me ask you this question. My mind's like,
you're trying to, yeah,
like processing this.
Yes.
So, are trusts for living people? Like,
yes.
It's all. Does it happen when people are living? Like, does the beneficiary sometimes receive it when people are living, or does it happen after they pass away?
It can be either one.
Either one.
Trust can be very flexible that way.
And then the trust, the grantor and the person who holds it title. Can be the same person.
They can.
Okay.
So we'll get to that. So here's another cheesy example of a trust. We'll keep building up to it.
Okay.
We'll use cheesier and cheesier examples.
I'm a good person to be processing with you because I have limited knowledge. So
that's great.
Okay.
This is perfect. This is education happening in real time. So let's say, in contrast, let's go back in time and pretend that I am a medieval lord, and I have a deed to my castle.
Okay.
And I have decided I will take the cross and I will go on crusade because that's what medieval lords do. But I don't know if I'm going to come back from the crusade. It's really far away. I could die in the crusade. Lots of things could happen while on a crusade. So I say, Rachel, I am giving you the deed to my castle for you to hold.
Okay.
Until I return or until my heir comes of age.
Okay.
Right? So you understand that I didn't give you my castle, Rachel, right? Like, you're not the owner of my castle for you to, like, move in and do whatever you want with.
Right.
You're holding it until I get back or until my heir grows up. Okay. And then you would give the deed to my heir.
So while I'm holding it, am I allowed to make changes to it?
Yeah, and then a whole body of case law came into being in merry old England about what you could and couldn't do while you were holding the deed for somebody else's. The formula in the olden times was for somebody else's use. Now we say for somebody else's benefit, but it's the same idea.
Okay, so very interesting. So that's like a basic. Do you have any more to share about?
And so another really common trust that you see is, it's colloquially called a revocable trust or a living trust.
Okay.
So people ask about those a lot.
So there's an irrevocable trust,
There's irrevocable trust and there are revocable trusts.
Okay.
So revocable trusts don't provide any creditor protection, and I'm going to tell you why.
Okay, so say that again. Revocable trusts
provide no creditor protection.
Okay.
So they don't provide any asset protection while you're alive.
Okay.
So again, I'm Laura, and I say, all right, this is my deed to my house.
Your castle.
It's my castle. And I say, I, Laura, give myself, Laura, the deed to my house in trust for my benefit for as long as I live, and I can get rid of the trust whenever I want or change the terms whenever I want.
Why would you ever do that?
Exactly, because doesn't that sound like I just own my house?
Right.
Yeah, because
so, I mean,
that's
just, like,
true.
I've seen them before, and I've seen them people get rid of them.
Yes, right, when they're selling.
Like, what is the point?
Because the point of a revocable trust is then it has instructions for what happens when I die.
Oh.
So it says, as long as I'm alive, I'm the boss. Like, I'm wearing all three hats. I'm grantor, I am trustee, and I am beneficiary. And I can rip it up and tear it up and change it however I like. But when I die, and that's a whole separate clause usually in the trust, but when I die, then my most responsible child will be my trustee.
Okay.
And my, however many children, 6, 8, 10 kids are all beneficiaries in equal shares.
Okay.
And it has some instructions about that. Maybe my most irresponsible child has a trust set up underneath this that says that that kid isn't going to get their money straight away
until they're 25
or
right.
Something like that. So that's where the will, it's almost like a will substitute. And the point of those kinds of trusts is, this is sort of beyond the topic of this conversation because we want to focus on asset protection.
Yeah.
But the point of those trusts is just to avoid a probate proceeding.
Okay, so that's good. So again, just to clarify, the point of a revocable trust, which happens when you're alive, which doesn't protect you from creditors,
none whatsoever,
is to
avoid probate at death.
Avoid probate at death.
That's it.
That's it.
That's all it does.
Okay, so then if you have the same situation but it's an irrevocable trust, how does it protect you against creditors?
So it doesn't protect you against all creditors, first of all. So if I created an irrevocable trust, but it was just like I said before, I'm the boss while I'm alive, but I don't have the power to change the terms of this trust. Even when I die, I don't have that. I still created the trust, so the creditor protection there is still not that great because I created it.
Okay.
Where you tend to see irrevocable trusts are for two things. Estate taxes, to avoid estate taxes. Get things out of your gross taxable estate, which is a magic legal term.
So they avoid estate taxes after you die?
That's the idea. Because the idea is to give it, the idea isn't that the trust just exists. The idea is to actually give assets away to someone else, so that way it's not yours when you die.
Okay.
And so the trust is irrevocable because you are giving up control of that asset.
So the estate doesn't have to pay taxes, but does the person inheriting have to pay taxes?
It
depends.
Depends. So that's a good segue into, so taxes are a great question. That's another reason why people say, well, maybe I need a trust because taxes, right? So let's talk about the types of taxes that can hit real estate. There's your regular property taxes.
Okay.
Those aren't going anywhere, right? Like those are going to be due once or twice a year to the town.
Right.
You're stuck with those.
Or the town will foreclose.
So you're stuck with those. No matter whether it's in a trust or not in a trust, you are stuck with those. What about other types of taxes? What about estate taxes? Well, I would say if your total net worth is more than $7 million, you should get advice from a lawyer about Maine estate taxes.
Okay.
Because in Maine, as of 2025, which is the year that we're in now, your gross estate, so that's everything that you own, can be worth $7 million, and you will pay no estate tax to the state of Maine.
Wow.
So that means for a lot of Mainers, they don't need to worry about estate taxes.
Let me ask you this. Okay, so does that mean if you're a Maine resident?
Mm-hmm.
So what if you're a Florida resident to avoid?
Florida, I can actually answer that question.
Let me just ask you.
Sorry, I didn't mean to cut you off.
You're fine. No, you're fine. So you live in Florida, because I don't fully understand the states, and so probably I could ask you 7 million questions today, but we don't have time for that. But so if you're in Florida, but you own property in Maine and Florida, and you're a Florida resident, do you still have to pay Maine estate taxes?
The answer to that is it depends.
Okay.
You might, in my experience, probably not, unless that's unless it's a $7 million property. Then again, come and get some advice.
Right. So that's like a complex question.
It is a complex question. It'll depend on the state that you're a resident of. It'll depend on the state where your children live to a certain degree, and it will depend on what the rules are here. And the reason I say it'll depend on where your children live is because some states have what we call an inheritance tax. Maine does not have an inheritance tax.
That's good news, folks.
That's good news. So you do have an estate tax, so that means the person who dies, their net worth, if it's over $7 million, the state of Maine will impose a tax. That doesn't mean that each individual person then also has to pay a tax when they receive their inheritance. I know that New Jersey, for example, they don't tax the estate. They don't look at what you own as when you die, but they do say if you live in New Jersey and you receive an inheritance from someone, you may owe inheritance tax on that.
Okay,
so it's the moment of taxation that's different.
Okay, great. So let's just recap on that. So for estate taxes, the total estate in Maine has to be worth over $7 million to be taxed.
Correct.
And then if you're a Maine resident and you receive an inheritance, there's no inheritance tax in the state of Maine.
There is not.
I think we need an applause.
Okay.
Let me see. All right, so we've talked about.
And then there's capital gains.
Okay, so talk about capital gains.
Yeah, sorry, I didn't
mean to. That's a big one.
That's the big one.
Capital gains is a big one.
That's the big scary one. That's actually what hits more families than estate taxes now. So when the estate tax exemptions were really, really low, like before the second George Bush was president, the estate tax exemptions were much lower. They were like $1 million, $2 million. So everybody was freaked out about estate taxes.
And inheriting things. Especially if they couldn't afford it.
Especially if they couldn't afford the tax. They were worried, oh gosh, we're going to have to sell everything to pay the estate taxes. George Bush came into, not the first George Bush, George H.W. Bush, he came into office, he moved it up to $5 million, and then it's been adjusted for inflation ever since. So that's why in Maine, now federally it's $13.99 million. So that's the federal estate exemption, and then the Maine state exemption is about half of it, so $7 million.
So overall, if someone's estate is worth under
$7 million,
no, federally $13 million, you avoid federal estate
13.99, so almost $14 million.
And then Maine is $7 million, but then where does capital gains tax come into play?
So capital gains tax only affects you if you sell a capital asset, right? Okay. So we're not Canadians. Hit the applause button if you want.
Okay.
So no offense to your Canadian listeners, but Canadian taxation is very different than Maine and U.S. taxation. Okay. So in Canada, they treat death like a sale, and it triggers a version of their version of like a capital gains tax.
Okay.
That is not the case in the United States, and it's not the case in the state of Maine. So if you inherit a property and you don't sell it, you just inherited a property. You're not going to pay capital gains tax.
But if it becomes your primary resident, like let's say you're a renter and it becomes your primary residence, then if you sell it
after you've lived there for a certain amount of time.
Right, after you lived there for 2 years.
Right.
Then you still don't pay capital gains, but
you have the primary residence exclusion, which is I think up to a certain dollar amount.
Okay.
Right?
So obviously you need to talk to
a tax professional. Talk to tax professionals about taxes.
But it isn't always that you get capital gains tax if you inherit something and you sell it, but
so the big loophole in capital gains for people who inherit property is the basis of the asset.
Okay.
So basis planning is important.
So it's how much it was worth when you inherited it.
Correct. So if you inherit a property either through a will, through the probate process, or intestate, which means somebody died without a will and their estate went through probate. So either through intestacy laws, through a will, or through a revocable living trust.
Okay.
Any of those choices, any of those options will result in what is colloquially known as a step up in basis.
Okay.
So it's not always a step up, it could be a step down, but generally for real estate, the market keeps going up, and so it's a step up. And so your basis in the asset for capital gains tax purposes is the starting point to calculate the gain. So if you inherit a property on January 1st, 2025, and your basis is whatever that property was worth on January 1st, 2025. Now, your mom and dad might have bought that property decades ago and it has almost a near zero basis in it. They never improved it, they never changed it, they just made regular repairs, and so they would have had a really low basis. If your parents had sold it before they died, there would have been potentially a capital gain, but because you inherited it through a will, intestacy, or a revocable living trust, your basis is now whatever it was worth when the decedent passed away.
Okay,
so if you sell it the next day, there's no gain.
Okay, so even if you sell it, like let's say you inherited something before the big market crash in 2008-ish. So let's say you inherited something and it was at its height in 2005 or 6 or something.
Sure.
So you inherited it and then you
held it.
And then you held it and you're going to sell it and
then for tax purposes, and again, talk with a tax professional because I know enough income tax rules to be dangerous. but I don't prepare income tax returns. But your basis would be whatever it was worth when you inherited it in 2000, whatever it was.
Mm-hmm.
And then it would be, it would be the difference between the basis of that 2000 whatever it is and what you actually sell it for. That would be your gain. The difference between A and B would be your gain. And then you'll be taxed on that gain at a certain rate depending on your income, depending on what the rules are in that year, brackets, all of that stuff. That's where you'd need tax advice.
Right, exactly. So it could be, it could be a massive gain or it could be a small gain. It just depends.
Or, God forbid, it could be a loss, which, you don't owe any taxes on a loss, but it's a loss. Right. So that's not ideal. But that's not really happening right now on Mid-Coast Maine.
Okay.
Things aren't really selling at losses.
So anything else about taxes that we should hit on?
Those are the three big ones. And so that can be a downside of irrevocable trusts. So the flip side, so that the happy news was, hey, I inherited this through a will, intestacy, or a revocable living trust. Well, what happens if we set up an irrevocable trust? Or what happens if mom and dad just gave me the house? They just gave me a quitclaim deed for the house one day. They just deeded it to me.
Okay.
Which was great because now I own the house, right? So that's the good news. If your mom and dad give you a house, you now own the house. That's exciting news. The downside is that your basis you're not going to get a step up in basis. Okay. You're going to have the basis of the person that gave it to you. Okay. Because you didn't pay for it. So you don't have a cost basis. Okay. Because that's our normal basis when we buy something. But if you didn't buy it or you bought it for $1 or something.
And sometimes that happens, and we don't have to get into the logistics of all of this, but if someone doesn't want to go to probate and they want a house, that they can add, their child to the deed with them, so when they pass away, it automatically...
So adding a child to a deed, so you mean adding them as a joint tenant with
a
right
joint
of survivorship?
Tenant, right, exactly. So that would be a case where...
There wouldn't be that
There's no step up.
There would be a step up on the parent's interest, but not on the child's, probably. So that would mean, so if the only people on the deed were parent and child, there's two owners, so you'd have a mixed basis in that. Okay. You'd have a mixed basis. I think I always shouldn't say always. I like to be able to really put my finger on the rule. And I'm sort of remembering what I think the rule is in that case. So somebody can double check me. Yes. They can go to their tax professional and make sure that I'm not making that up, that my memory is accurate, that's true for joint properties.
Okay, and that's a gray area. Doesn't really pertain to the topic, but it's a way to get around all of that.
It is.
But it's not, you don't get the benefits.
You don't get the same benefit. You get some benefits and you get some risk, because when you add a child as a joint tenant, they own that house with you. If you go to sell it,
they have to sign off.
They have to sign off on the sale. They do a check at closing. Right. If they go through a divorce, if they go through bankruptcy, they own part of that house. So there's some downsides to I'll often get a question, I just want to add my kid on the deed. Well, do you want to give an interest in your house to your children? Well, no, I just want to add them on the deed. Well, what does that mean? So we have conversations with clients about what their expectation is when they just add a kid on the deed to make sure they fully understand what they're doing. There are now in Maine things called transfer on death deeds. Okay. I personally am not a huge fan of them, but they are, I think, they do have a place, but they're relatively new. So lawyers tend to like things that have been around for a long time and that they're exactly sure they understand how they're going to work. Right. The statute is very clear. It should work just fine for most people. But I've had some cases or heard of some cases, they're not my cases, but heard of some cases where they don't work as expected. And so I'm a little cautious about them. Yes. I'm a little cautious about them.
And that's to avoid probate, probably.
That's also to avoid probate. Okay. But also does not offer creditor protection. Like a revocable trust doesn't offer creditor protection, or like a will doesn't offer creditor protection. It's just something that says, when I die, I want so-and-so to get this property.
And I think that when you talk about creditor protection, when you do an irrevocable trust, does that protect someone from main care? Maybe you can't answer that. I
can answer that. So you're sort of fast forwarding right to the end. Let's get to that irrevocable trust and figure out how that works. But and that's fair. Let's try to get to the nugget. So the reason lawyers tend to say for people who say, I don't want the state to get my house.
Right.
That's a common
right.
Way that people will phrase their goal to me. They'll come and they say, I'm coming to see you because I heard that the state could take my house if I go into a nursing home, and I don't want the state to get my house. I want to make sure my kids get my house.
It's a big fear.
It's a big fear.
fear.
It's not, and I'm not poo-pooing anybody's fear, but when they come in to see me, that's how they're phrasing it. I need a trust because otherwise the state will take my house. Let's break that down, right? Like, let's break that down and make sure we understand, will the state maybe take your house? Let's make sure that that's potentially true first.
Okay.
So the first questions I tend to ask people are things to see if there are other ways that they might be able to finance their long-term care.
Okay.
Other than applying for state benefits. So one way that a person could pay for long-term care is maybe they have a long-term care insurance policy.
Oh, okay.
Maybe they've already bought that long-term care insurance policy. Now, most clients know if they have that policy because they're paying a premium.
Okay.
And it's usually not a cheap premium. So
Okay.
most people who have that kind of policy are very aware that they have that policy. It's not to be confused with like long-term disability. That's something else. That's a different type of insurance. This is long-term care insurance, LTC, long-term care. It's usually a private policy. It's usually not offered by an employer.
And people purchase that like well before they are going
Usually people look into buying them around retirement age.
Okay.
And it's a privately held policy. And they're crafted in different ways. So they might say, if you pay this premium and then you need a certain level of care, we will pay X dollars total. Like, there's a defined total benefit. Or they might say, we will pay for X number of months in a facility.
Okay.
All of them are a little different. So if somebody's listening to this and saying, ooh, that's interesting, maybe I'll go out and buy one of those premiums, I'd say, great, just go to somebody who's licensed to sell insurance. Go to a broker who can maybe shop around a couple of different policies and make sure that you understand the policy you're buying.
Okay.
And make sure it's the kind of policy you want. Like, if you're saying, I want to have live-in care. Right? Because a lot of people want to age in their home. That's their primary goal. Well, then don't buy the policy that just covers nursing home care. And doesn't cover in-home care. Like, just be attuned to the fact that different policies offer different benefits. Make sure that you're paying for what you actually want.
Okay.
So that's the first way that maybe your long-term care is going to be covered by this policy that you've bought. Another group of people that sometimes have access to long-term care are veterans of the United States Armed Forces.
Okay.
So veterans of the United States Armed Forces, depending on when they served, did they serve during time of war, for example? That doesn't mean that they had to actually serve in a combat zone. That means that they served in time of war. So when the United States was in an armed conflict. And it also depends a little bit on which time of war they were serving. In general, the trend I see is the older veterans have better benefits than the younger ones. I don't specialize in veterans benefits, but that's a trend. I think I think it's a fair generalization.
Does it also depend, and we won't get into this, like, as far as, like, coverage for long-term care too much, but with veterans, it also depends on, like, when they go into a veteran facility.
Yes, that's true. So the type of benefit that you're eligible for is important. So you have to have your honorable discharge, because some people say, well, I'm a veteran of the armed forces, but I have no idea what I'm eligible for. So the first step is find your honorable discharge. And the second step is reach out to the VA and figure out what you're eligible for. If you're a 100% disabled veteran, it's pretty likely that you're going to qualify for a lot of benefits. If you're not a disabled veteran, if you didn't serve in time of war, you might not qualify for a veterans home. When you get older, you might not qualify for what's called aid and attendance, which is a very nice program that provides people with in-home care.
Okay, and then you also may qualify for long-term care in a facility, but the facility has to be available.
It has to be available. So if there's not a bed, for example, that could be a problem. The other issue that people will sometimes ask is they'll say, well, I'm the veteran, but I don't need it. I'm healthy. I need it for my spouse. That's a too bad, so sad situation. So the only spouses that are eligible for benefits through the VA are basically war widows and war widowers. So if you lost your spouse during time of war because they were killed in action, then you might be eligible for some benefits. But if you're just married to somebody who served during time of war, you are probably not eligible for benefits.
Okay.
Again, you can double check me with the VA, but that's my general understanding.
Okay, so moving past the long-term care
and then those are the two, and then there's private pay.
There's private pay.
Private pay is just what it sounds like. You write a check. That's the third way. We're getting on to the fourth one, which is main care. I promise. We're getting there.
You're doing good. You're doing good. So